we're going to head over to the Supreme Court, where some justices could consider cutting back the regulatory power of federal agencies. And joining me now is Zach Schoenfeld. He's the courts and legal reporter with our media partners at The Hill. Zach, thanks for joining us and welcome back.
Always good to be with you.
Well, why are some justices considering pulling back power from federal agencies?
I think you've seen this conservative majority on the Supreme Court in recent years really take a look at what has become known as the administrative state. We're not talking about here one agency or one policy area, but rather we're talking about the ability of agencies across the federal government and presidential administrations to issue regulations and try to enforce various things. So here, the underlying case has to do with the herring fishing rule, but the implications could be much broader. At the arguments, the justices were talking about the potential implications on artificial intelligence, cryptocurrency, environmental protections, and more. And what we've seen from a lot of these conservative justices on the court is a skepticism to federal agencies and a notion that federal agencies have been growing, that they've been exceeding their power, and that the courts need to step in and claw back their power to, in some of the conservatives' mind, put the agencies back into what should be their constitutional bounds.
We talk about this legal doctrine. It's helped agencies in the past. Has it sort of been like their protection?
That's right. This is a doctrine known as Chevron deference. It originated back in the 1980s, actually during the Reagan administration. And what it has allowed in the 40 years since is it has required courts, when plaintiffs have gone into court challenging various regulations, that if a law is ambiguous, that courts are required to defer to an agency's interpretation of that law. So what does that mean in practical terms? It means that if Congress passes a law, it's ambiguous or silent on a given issue, that courts have no authority to just step in and stop a regulation from taking effect so long as that agency has issued its regulation in some sort of way that is based on a permissible reading of the statute. So presidential administrations in both parties, not only Democratic administrations, but Republican administrations have have used Chevron deference to implement various regulations that the courts, as challenges have come through, just have really basically in almost all cases, the government wins.
You know, if they were to rule to cut back power, what impact would that have on Americans?
Well, the exact impact will remain to be seen on exactly how this opinion comes down. But generally speaking, this could really claw back the ability of presidential administrations to put out regulations across the board. So whether we're talking about Democratic administrations maybe wanting to implement various regulations on the environment, or maybe we're talking about a Republican administration that wants to implement regulations, something related to the economy somewhere. No matter what the policy area is across the board, it would weaken the ability of presidential administrations to put these regulations forward without clear authorization from Congress. So Congress would have to speak more clearly in the laws they pass, telling agencies you can or cannot do this. But this idea that Congress can pass a law that's somehow ambiguous and that agencies can then try to work out any reasonable meaning would no longer be in effect. They would really have to see more clear authorization in federal law.
Do you think everyday Americans are waiting to see how this comes down?
You know, I know this is sometimes doesn't get, it might not seem as catchy or as flashy as some of the other issues that have come to the court, whether it be abortion or guns and some of the other big cases that we're seeing. But I think when this decision comes down, likely in May or June, it could have huge impacts that are right up there with those various gun and abortions decisions. And I think, you know, it's a little bit of a different case because we're talking about administrative law here. We're not talking about one particular policy area. But no matter what you can think of, if you name an agency, depending on how this ruling comes down, it could really shift their ability to implement regulations just across the board. So I think Americans should be caring a lot about this case because I think it really could have major impacts when this decision comes down.
Do you expect this ruling to go along political lines, or?
I think we'll see if it really does end up quite on that 6-3 ideological lines that we're sometimes used to seeing. From sitting at the oral arguments this week, I think you saw a few of the conservative justices, though, having some hesitation to quite go all the way and issue a ruling that just says Chevron is hereby overruled. In particular, we saw two of the conservatives, Justice Amy Coney Barrett, who is Trump's final appointee, as well as Chief Justice John Roberts, expressing hesitations on multiple fronts. So now the question becomes, do some of the other conservatives who seem more bullish on overturning Chevron, justices like Clarence Thomas and Neil Gorsuch, Trump's first appointee, can they pull the other conservatives along with them to form a 5-vote majority? Or will Justices Barrett and Roberts be able to form some sort of compromise or some sort of ruling that doesn't quite go all the way to overturning Chevron outright?
Zach Schoenfeld with The Hill, thank you very much for joining us.